Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
Yeah. Roberta in the truth zone, mic hitting raw. Spotlight shining, she exposing the flaw. Debunking the myth, breaking their facade. This is Glass City, respect the squad. On these NYC blocks where the skyline flex big. Roberta Glass slicing lies with a truth rig. Innocence frosters, your stories unravel. She's a map through the madness of gritty gravel. Glass don't bend and facts don't break. She's a storm that's called, you feel the quake. Exposing tales stitched with crooked seams. Justice in the lens, shattered fake dreams. Screams about killers, painted heroes in disguise. She burning propaganda with fire in her eyes. No glamour for the guilty, she call it straight. She backs victims, the voice stay awake. Stats and receipts, no spin, no clutter. Cold cases whisper, she cuts through the mutter. Truth's her tempo, don't confuse the beat. She's standing for the real while you taking a seat. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time to play. She's glass hard, break the false and save the day. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time.
Okay. How is everybody? Good morning, Tammie. Good morning, Maestro. Good morning, Iowa RRT. Good morning, Susan. Good morning, Cat in the Hat. Good morning, Albert. I'm glad you caught alive. While we're waiting for Karen Read's hearing to start, I wanted to thank Tammie, Janet Gillis, Marie Horton, Tammie, again, John, Dan Lawrence, and Averill for buying me a coffee. I appreciate it. Best way to support this show is becoming a Patreon member. Patron. You can buy me a coffee, Venmo, all in the description of this episode. Or I hope so. I hope I'll put it in the description of this episode by the end of the day. So I wanted to share with you the filing because it's quite explosive and it's what I've been saying all along. You know, I've watched so many and reported on so many of these innocence fraud campaigns. Usually they're post-conviction, post-litigation. And I've waited. So I've watched them rise in popularity. The media gets on board. And I've watched these other creators just raking the money on these innocence fraud campaigns. And I've sat with the truth on the unpopular side of the argument and just waited until they collapse. And ultimately they do collapse because all these innocence fraud campaigns are born on sand. I'm not saying that a lot of them get away with it. They free a lot of killers, murderers out of jail, dangerous people. But the popularity of them ultimately diminishes, and then the followers go on to another innocence fraud campaign. So Adnan Syed, making a murderer. And so we're seeing, and then they go on to Karen Read. And this narrative of wrongful convictions is like, or wrongful accusations in this case, it's like crack to Americans and worldwide. I'm not saying it has worldwide appeal. It's not just in America. So this was quite explosive. Let me just take off the ad here. Hold on. The Commonwealth versus Aidan Kearney and Karen Read. Oh, wait, hold on. Hold on. One momento. What I really wanted to show you, give me a hot minute here. It's the morning. Is the affidavit against Karen Read. Hold on. It's the filing against Karen Read. It's like unbelievable. Let me make sure I have the right thing. Because it's, again, what I've been saying all along. The problem is not just Aidan Kearney. He's not someone who just attached himself to an innocence fraud campaign and did this all alone. This is really Karen Read's legal strategy. They can't win inside the courtroom. So they start an innocence fraud campaign. They start a witness harassment campaign. And what you'll see in this filing is that it's not just Aidan Kearney acting alone. This is all about Aidan Kearney's phones, the hearing for today. And they have some of his phones. He had multiple phones, and they haven't gone through the others. Also, another big revelation is what, again, I called it, is that when they went to the grand jury with witness harassment charges and more witness harassment charges for Aidan Kearney and brand new witness harassment charges for Karen Read, they didn't have all of the evidence they have now from their phones. But here's Attorney Yannetti telling Aidan Kearney he's a class act. You're doing God's work. That when Aidan Kearney told him that he's going to hold a protest at the courthouse steps where he will have a megaphone this time and make sure hundreds of people are there, Yannetti responded with that he loved it. So there's multiple communications, as we knew, between Yannetti and Kearney and Alan Jackson and Aidan Kearney. And if this is not something to report to the par, I don't know what is. All of their behavior in this case has been so off the charts, deplorable. So let me share my screen and we'll go through the filing together. Yeah, David Yannetti, Kimmy K says, David Yannetti was on those call logs way more than I thought he would be. Absolutely. I've heard 6, I've heard 4. I'm not exactly sure how many phones he has. Quite a few phones. If it's 4, it's still a lot. If it's the lower number, it's still a lot. Hold on one second, guys. Okay, so this is the Commonwealth versus Aidan Timothy Kearney. Commonwealth's opposition to defendant's proposal to compel screening of seized devices for purported reporter's privilege. So he's claiming reporter's privilege here. And that doesn't really exist in Massachusetts regarding this case, I believe. It's not a source, Karen Read. Isn't, I mean, I don't know. I guess you could call her a source if you're going to really stretch the truth. But on October 11th, 2023, I mean, we went through this with Gretchen Voss, is that there really aren't laws in Massachusetts in this way that protect reporters and their sources if something criminal is going on. October 11, 2023, the Commonwealth seized pursuant to multiple search warrants electronic devices from the defendant Aidan Kearney's home. Okay. 2 were primarily searched under authorities and warrant. Therefore, the defendant, through counsel, asserted that there was material on the devices subject to attorney-client privilege. The Commonwealth thereafter agreed that it would not search those devices without first implementing a taint team. Didn't we just hear Aidan Kearney on that Justice Served TV saying that no taint team was used? Didn't we just hear him say that? Did I misunderstand? Discussions with the defense follows as to appropriate members of the taint team, and Special Assistant District Attorney Kenneth Mello identified an expert, Stephen Verneau, to exact the information from the electronic devices, and retired District Court Judge Joseph Macy to screen out protected attorney-client communications, and confirmed with them their willingness to serve in that capacity. For reasons previously litigated but not germane to the present discussion, the Commonwealth made no progress in advancing the search of the devices until August 12, 2024, when it filed with this court a motion for examination of the digital devices. The Commonwealth anticipated its motion would be heard on the next court date, but 5 Superior Court appearances followed considering intervening matters before this court reached the taint team question. On December 27, 2024, this court issued an order establishing a taint team review procedure. In pertinent part, it provided that defense counsel file with the court, oh wow, it's late, a list of search terms to facilitate the taint team. Okay, so as a general rule, the question of reporter's privilege arises in the context of reporters subpoenaed or summoned to testify. The lead federal case is Brandsburg versus Hayes. Darren Brandsburg, as well as a New York Times reporter and a Massachusetts television reporter, Pappas, were subpoenaed before separate grand juries in order to name the sources of their articles. They refused and were held in contempt. Writing for the court, Justice Byron, while declined to find in the press clause of the First Amendment a testimonial privilege for newsmen that other citizens do not enjoy. However, White noted favorably a previously established test requiring the government to convincingly show a substantial relationship between the information sought and a subject of overriding and compelling state interests. Therefore, the judge should examine the reporter's claim on its face by striking the proper balance between the freedom of the press and the obligations of all citizens to give relevant testimony with respect to criminal conduct. Subsequent federal cases have attempted to apply Brandsburg, but have ranged widely in their interpretation of it. Massachusetts, likewise, has not legislatively adopted a reporter's shield law. Bills establishing a reporter's shield have repeatedly been filed in the legislature and have uniformly died there without passage. Okay, I'm just going to skip forward. Just going to try to get to the pertinent parts. Okay, this is all about the Taint team. Okay, Judge Krupp's order authorizing a taint team procedure provides only for screening for attorney-client privilege materials. So they're saying the taint team should cut out all communications between Aidan Kearney and his source, which would mean Karen Read and her lawyers. But, I mean, I don't even think you could call David Yannetti and Alan Jackson a real, I don't guess you could call them a source. But, I mean, it just looks like they're in poor legal standing here. Under the case-by-case analysis, okay. This is where it gets really good. Okay. Since raising its objection to inclusion of terms designed to screen out communications with Read's defense attorneys on November 30th, undersigned counsel has reviewed some of the data from one of two cell phones lawfully searched pursuant to warrant prior to any defense request for taint team. So there's two that were already searched, and the other phones, let's just call them two phones, are waiting to be searched. Its contents strengthened the Commonwealth's argument here. Kearney's phones contain text messages not only between the defendant and Karen Read, but the defendant and attorney Yannetti and or Jackson as well. The text exchanges also make clear that the Read team was in telephonic and email communication. The same people. The Read team repeatedly provided Kearney with information, including videos and copies of documents, sometimes with a request always acceded to that he not use it or not use it yet, lest the Commonwealth discern its source. This is like a criminal enterprise here. At times, they would suggest angles for Kearney to cover or otherwise ask for his assistance. For example, on 8/8/2023, retexted Kearney, "Do you have the memo town employees were emailed about speaking to you reporters? Alan wants to blast it." The Read team responded to Kearney's specific request for information, discussed strategy. That should be interesting. And quite frequently stroked his ego by effusing about his YouTube presentations. Kearney reciprocated by passing along information. So they sort of, not only was he a part of the team, let's say this, he got that kind of ego needs met by being part of Karen Read's team, but they summed him up as someone who needed a lot of ego stroking and cheerleading. Kearney reciprocated by passing along information he has come across, his own theories, and the name and contact information of certain potential witnesses. Both the Read team and Kearney took pains to conceal their actual relationship. For example, on May 3rd, 2023, Yannetti texted Kearney, "Jude, don't be offended if we don't shake your hand on the way to court. I'll pat your butt instead." That's me saying that. "We want to maintain the separation and your independent investigation." LOL, independent investigation. The Commonwealth wishes to delay the tainting procedure. Let me just check in to see if anything's going on in the courtroom. Hold on. Oh, we have a fan. So I'm going to continue to read this, but I'm going to just switch tabs. The Commonwealth wishes to delay the tainting procedure no more than absolutely necessary. The tainting procedure is necessarily a time-consuming one. Under the order, after examination and initial screening and determination of potentially privileged material, the information is to be provided. So here are some representative examples from Attorney Yannetti. On April 22nd, 2023, he texts Kearney, this is the footnote. That was priceless, dude. Great effing, my words, not his. I can say it. Great fucking show. Really enjoyed the turtle reporting. On May 29th, Yannetti assured Kearney, you're a class act. Karen and her parents, thank you. A few weeks later, on June 9, 2023, he texts another great article by Turtleboy. Just keeping an eye on the courtroom. Let me just turn it on. Turn on the sound.
Attorney Cosgrove? Attorney Cosgrove? Yes. Do you want me to call security? All right. You let me know. Exactly. Thank you.
So a little levity in the courtroom. A few weeks later, on June 9th, he texted another great article by Turtleboy, you are doing God's work. Told by Kearney on June 9, 2023, that on July 25th, he will hold a protest on the courthouse steps, that he will have a megaphone this time and make sure hundreds of people are there. Yannetti responded that he loved it. On August 18th, does this really say 83? I think this is a typo here. I think it should read 23. It reads 83. In response for Kearney's request for names of criminal defense attorneys who might want to appear on YouTube discussion panel with him, Yannetti forwarded him the name of 4 lawyers and their cell numbers and suggested how to approach them. Unreal, right? Maybe we'll get to the rest at a break. But pretty amazing.
Now I can just go Zoom.
Kimmy K, thanks for the super sticker. Manny. Kimmy K, gorgeous.
Enter your meeting ID.
Manny, I think Turtleboy and Karen Read supporters are MAGA adjacent, are they? I don't know. I know Turtleboy supports Donald Trump, but I don't know about the rest of it. I don't think there's any uniform.
ID followed by pound. Otherwise, just press pound to continue. You are in the meeting now.
I don't think there's any uniform ideology. This goes on both sides of the fence. Political fence, innocence, fraud. Certainly.
are muted.
There's Elizabeth Little and David Yannetti on Zoom, looking, or I guess that should be Alan Jack. Is that David Yannetti?
I think I'm all set. Oh, is it ready?
You are unmuted.
Looking like a hostage
Can
video.
you hear me?
Yes.
Audio off. No sound.
You are muted.
So what am I doing? Through FTR.
Right, but do you have to have audio going out of the monitor?
Yeah, you have to have audio going out.
Can you record it with the monitor on you?
You are unmuted.
Hello?
You are muted.
I know we got around it in trial, but it took like, I know Victoria has that.
Try it again.
You are unmuted.
Do I fix it? No. Mute it again.
You are muted.
Manny says, so it's a combo of Working Poor and Rabia fans, Innocence Project fans. Yeah, I think a lot of these go from one Innocence Fraud campaign to the other. From Luke Mitchell to Richard Glossop to Adnan Syed to Stephen Avery and Brendan Dassey to Amanda Knox to Brian Ferguson to, I mean, how many can we list? How long do you have? Thanks so much.
Okay, so the TV's muted.
Okay. Let's try it again.
You are unmuted.
Hold on for a sec. Muted.
Just do it one more time so Tori can hear.
You are muted. You are unmuted.
Mute, unmute you again. Nope.
You are muted.
I think I might be able to put it up here. It's coming out of here. okay. I muted everyone. I muted everyone. I may not be able to do this. Okay. We're gonna have to go back to the other way. That's right. Oh. Can you, what? Do you have a guy coming in on water? Okay, is he in? Okay. We can take care of it after this. With Judge Jude. That's fair. What? Thank you.
Welcome to Zoom for Government. Enter your meeting ID followed by pound. Enter your participant ID followed by pound. Otherwise, just press you are in the meeting now. There are 12 participants in the meeting. You have been added to the waiting room. You cannot talk or listen until the host admits you to the meeting.
Wow, this is some punishing music, no? So when I told my boyfriend about this like incredible filing, I was just reading him that footnote with Yannetti. He was like, well, we knew this because on your page, your channel had been captured at the courthouse, and I had downloaded it, or snipped it when it happened. I think we should watch it again. David Yannetti patting Turtleboy's butt for job well done. Should we watch this again? It's real fast. Did everybody see it? We'll do it one more time. Yep. Slow motion. There it is. There's David Yannetti. There's Turtleboy. And he has K for Karen shaved into the back of his head like a cult member. Unreal, right?
What?
Yeah, I would die too. Kitty K, if Law and Crime played my song about Alan Jackson, do you mean? Or I hit my boyfriend with my car, which one?
You are unmuted.
Do we still have the echo? No.
It's a little better.
Do you have an echo?
It's there anymore.
It's gone.
Okay. All right, I'm all set.
What happened to the feed? Did the feed just go down?
I'm all set.
Okay.
Folks, make sure your cell phones are off and put away for me, please. Thank you.
Judge, this is 22-117 and 23-313, the Commonwealth versus Karen Read, and separately the Commonwealth versus Aidan Karen. Can I have the parties identify themselves?
Mr. Clerk, hold on just a moment, please. Sure. I need to plug in because I believe we have parties on Zoom.
Okay, I'm sorry.
It's also my understanding that we're only here on case 0117.
That was also my understanding.
Okay.
Thank you.
And do you have the Zoom identification link for me, please?
I do. It's right here.
Thank you.
There's no passcode.
Thank you. Okay, Mr. Clerk, you may
Judge,
call off the
thank
case
you.
and identify the parties.
22-117, the Commonwealth versus Karen Read. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Hank Brennan for the Commonwealth relative to docket 00117.
Good morning, Attorney Brennan.
Good morning, Your Honor. I'm Robert Cosgrove. I'm a special prosecutor on the Aidan Kearney cases, and I suppose for purposes of this motion, I'm the respondent to the Rule 17 motion.
Good morning, Attorney Cosgrove.
Good morning.
Hello, Your Honor. Timothy Bradel for Aidan Kearney. I see him on the Zoom for the record.
Good morning, Attorney Bradel. Good morning, Mr. Kearney.
And Mark Federer for Mr. Kearney. Good morning, Your Honor.
Good morning, Attorney Federer.
And good morning, Judge. Attorney David Yannetti for Karen Read, who is also present on the Zoom.
Good morning, Attorney Yannetti. Good morning, Ms. Read.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Read.
Good morning, Attorney Little. Anyone else here that we need to recognize before we proceed? Doesn't seem so. Okay. Folks, we are here on two related matters this morning. As an initial matter, we are here because there seems to be some confusion concerning my order of March 20th on docket 615 on the Commonwealth's Rule 17 motion. Also, we're here because there has been a motion for protective order, docket 636, filed by intervener Kearney, and so we will hear that as well. So with regard to my order, let me start by saying this. Going back to Attorney Brennan's affidavit filed in this case on March 5th, 2025, in support of the Commonwealth's motion for records, Attorney Brennan, you specifically stated that, quote, it's been represented to the court by defense counsel Bradel on behalf of Mr. Kearney that there's an implicit long-term mutual assistance and mutual defense agreement between counsel for Mr. Kearney and counsels for this defendant, Read. On the basis of that sworn statement, I specifically inquired of you, Mr. Brennan, at the hearing on this matter last week, do any of the three categories of documents and data that the Commonwealth seeks by the Rule 17 motion include communications with Mr. Kearney and counsel for the defendant in this case? You replied, no, these would be privileged. So based on these representations and the court's belief that there were no privileged materials implicated by the Commonwealth's motion, I ordered that all communications between Mr. Kearney and Ms. Read during the time frame in question with regard to these three articulated categories be produced. However, Subsequently, the special prosecutor in Mr. Kearney's case, in possession of the documents in question on March 26, informed the court that one, there are in fact a substantial number of communications within the documents and data requested that are indeed communications between Mr. Kearney and Ms. Read's counsel. And moreover, the special assistant district attorney in that case took the position, contrary to the one asserted by Attorney Brennan in this case, claiming that those communications are not, in fact, privileged. So my order did not specifically exclude from production communications between Mr. Kearney and Ms. Read's counsel because the court was told there were no such communications, and in any event, the Commonwealth acknowledged that they were privileged. So my first question is to you, Attorney Brennan. Respectfully, did I misunderstand you, or perhaps vice versa? In other words, I understood that you weren't requesting the production of any privileged communications, to wit, communications between Mr. Kearney and Ms. Read's counsel. And as such, if that is the case, and we did understand each other, I can simply clarify my order for Special ADA Cosgrove that those claimed to be privileged communications will be excluded from the Rule 17 production, and we can move on. If that's not the case, I'd like to hear why.
Sure. May I?
Yes, you may.
I think there are two separate issues regarding privilege. One is whether Mr. Kearney's attorneys, Mr. Betterow and Mr. Brado, have privileged communications, and separately, Ms. Read's attorneys' communications with Mr. Kearney. When Your Honor asked the question, I believe we were referring to Mr. Kearney's attorney. And so what I understood from the motion filings is that there were no privileged communications between Mr. Kearney and his attorney in those phones. And so there would be nothing privileged to protect.
Okay, I specifically asked, does this include communications between Mr. Kearney and counsel for the defendant, Read?
I don't doubt that you asked that if that is what happened, but that wasn't my answer to the question because perhaps I was focused more on Mr. Kearney.
So you confirmed today that we misunderstood each other?
Or I misunderstood. I'll take responsibility for it. But I was trying to be protective of the attorney-client privilege between Mr. Kearney and his attorneys, Mr. Brado, Mr. Betterow.
Okay, well, we all agreed, counsel, that those in fact would be privileged communications without question.
Of course.
So let's turn to, if you would, the second issue, which is one that you raised in your affidavit. You specifically raised that question in your affidavit, docket 547.
Undoubtedly. I do not believe there is any attorney-client privilege between Ms. Read's lawyers and Mr. Kearney, because those communications are not covered by attorney-client privilege because none of Ms. Read's lawyers are attorneys for Mr. Kearney. I pointed out that in an earlier hearing, and I have the transcript of it, it was December 17, 2024, when there was litigation in Mr. Kearney's case, docket 0313, that there was a position taken by Attorney Brado. And he began by telling Judge Krupp, well, there's a joint defense issue, Your Honor. And Judge Krupp asked, so it would predate any jeopardy of Mr. Kearney. And then Mr. Brado responded, well, it's a little more complicated because we know he was under investigation along with Ms. Read without any resultant charges, so we would contend that does not fall under the umbrella. After more questions by the court, Mr. Brado answered, we don't have an agreement, but there's been an ongoing long-term implicit mutual assistance and mutual defense that I myself have been part of for a long time, and Attorney Betterow has as well. And Judge Krupp said, I really have no idea what that is. And so inevitably, there was no establishment of an attorney-client relationship between the two. Inevitably, and after that, Attorney Betterow attempted to file an appearance on behalf of Ms. Read. And in that, there was a supplemental motion, and it's docket 549 on 0117.
And docket 549 contains Attorney Yannetti's sworn statement that there was no joint defense privilege between Ms. Read and Mr. Kearney.
Exactly. And so I think I had the assumption there was no attorney-client privilege. If I misspoke, it confused the court. My apologies, but inevitably, there is no attorney-client privilege that I understand exists. And so I do not know what is in these phones. I have not asked. I don't want to know unless it's pursuant to a court order. But based on the affidavit of the search warrant and based on the pleadings in this case, and there's two very important pleadings, I may have mentioned them to the court on the last date. But those pleadings, which were filed publicly by the Commonwealth, and it's docket number 53 relative to Mr. Kearney's case 0043, in that pleading, it is set out by the Commonwealth pleading that there is, in fact, information demonstrating that the Read team provided Mr. Kearney with information, documents, videos. It's suggested that at times they would suggest angles for him to use it or to refrain from using it. And it provides a number of examples, including an example on 8/8/23, when they're asking for information, Mr. Kearney, so one of the attorneys.
Attorney Brennan, I'm going to ask you to pause right there because I think we've reached a point where I have a threshold issue that may require either a Bishop Franklin protocol or some inquiry into the nature of the privilege that may or may not be asserted by Attorney Bradel. And so I think it's appropriate at this time, Attorney Bradel, that I turn to you, not with regard to the protective order, but with regard to the issue of whether your client claims a joint defense agreement and related privilege to communications between himself and attorneys for Ms. Read, such that I need to limit the scope of my order of March 20th.
Judge, thank you. We do not assert such a privilege. I said in a much different context a long time ago that we had been sharing information and talking to each other and helping each other. And I said that there was an issue. I didn't say there was a privilege.
Okay.
So we are not asserting that. There is no formal agreement. There's no formal privilege. I said it was an issue to be looked at the time. That's all I said, Your Honor. And in terms of this, Your Honor's order, I don't even know why we're talking about this, Your Honor. The ostensible purpose of the Commonwealth's request was to attempt to show consciousness of guilt on the part of Ms. Read. So why would communications to other parties besides Ms. Read have any relevance? And in fact, in your order, you just say that the only communications that are on the table here, so to speak, are communications between Mr. Kearney and Ms. Read.
I'll stop you right
Nothing
there,
about
Attorney Bradel,
lawyers
because you
or
raised an excellent point, and that point being is that point from the court's perspective is in an age of group texts and other means of communications with multiple recipients at the same time, we certainly have the likelihood of communications between your client and Ms. Read that may also include members of her defense team. So it is my belief that is what might be at issue, but I will probe further of ADA Cosgrove on that point.
I mean, if you ask me, Your Honor, the pleading, that the impounded pleading filed by Mr. Cosgrove is completely immaterial. The whole reason for this is consciousness of guilt. So there are we are privy to these extractions. There's absolutely nothing in them that is covered by Your Honor's order. There's no communications between Mr. Kearney and Ms. Read regarding witness intimidation. There are none. So there should be exactly zero documents or texts or emails that should be responsive here. Absolutely zero. And I don't have the thumb drive that Mr. Cosgrove gave to the court ex parte. So I can only imagine what's in that. And we are anticipating a request that you will look at that, to ask you to look at that in camera and see if that complies with your order. It doesn't. It cannot comply with the order. Your order said Kearney and Read, not third parties that may or may not have spoken to Read. And these are things that are privileged among that team. So this is a can of worms that the court did not open by any stretch. And I think that, Mr. Cosgrove's role here is completely ministerial, Your Honor. And the fact that he's trying to jump outside of your order is incredibly inappropriate, in particular because these two prosecutors are in different positions due to a conflict of interest, an express conflict of interest that has been identified and supposedly acted on by District Attorney Michael Marcie. So their communications need to be limited because there is a conflict. Your Honor limited those communications very appropriately to potential evidence that those two defendants could have communicated and in terms of some criminal acts. And we're telling you there's nothing there. We don't expect you to rely on our interpretation, but there is nothing there relative to your order.
Thank
So
you.
the fact that
Attorney Breda, I'm gonna ask you to pause for a moment, and I'm gonna hear from Special Assistant District Attorney Cosgrove, specifically with regard to this issue. In your communication to the court, you suggested that in your judgment, the production would sweep in a substantial number of communications between Mr. Kearney and Ms. Read's attorneys. How would those be swept in when the order specifically calls for communications between Mr. Kearney and Ms. Read?
I think the actions of Ms. Read's attorneys on her behalf are the actions of Ms. Read. And if one reads the sweep of the communications between Mr. Yannetti and Mr. Kearney, and between Mr. Jackson and Mr. Kearney, and Ms. Read and Mr. Kearney, one sees a pattern of feeding information to Mr. Kearney. I think that they act together in that respect, Your Honor.
Thank you, Attorney Cosgrove. Notwithstanding that position, the court's position is that the order spoke very specifically and very clearly to limit the Rule 17 motion to the production of only communications between Defendant Read and Kearney and Defendant Kearney concerning those three areas of inquiry. So I am specifically requesting and ordering the Commonwealth in that case to review the documents called as a result of the Rule 17 motion in my subsequent order, such that the production will only include communications between Kearney and Read.
Well, I will, of course, comply with Your Honor's order.
Thank you. Folks, I think we've covered that point, and I don't think I need to hear any further on this. The order is clear on its face, and I expect the parties to comply with it. I'd like to turn now to the issue of the motion for protective order from Mr. Breda. So I'll hear you on this, appreciating that I have had the opportunity to review the attachments and certainly the basis for this, but I'm not, I'll preview where I end up, Attorney Breda. I'm not quite clear on the scope of your request as contained in your draft order. As an initial matter, I'm only issuing an order in the Read case. I am not, this is not a hearing on the Kearney case. I appreciate that you have a congruent request to the court in the Kearney case, and that it may make sense that whatever the court does in that case should follow what the court does in this case. That would seem to make sense. But I'm only hearing the motion as it regards to this case. Your request, I'll note, asks that the court order all prosecutors and police in the above captioned case to maintain the confidentiality of the cell phone data and any other investigative information and or discovery in each case. So I'm not prepared to discuss the entirety of investigative information and all discovery in this case. I am tasked with only addressing Mr. Kearney's specific cell phone data that is the subject of my order of March 20th. But you've specifically requested that the court order that police and prosecutors are ordered to refrain from sharing such information with particular parties identified in Mr. Kearney's affidavit and any other parties not part of the retained prosecution teams of Ms. Read or Mr. Kearney. Aren't they already under a duty not to share such information with anyone outside the bounds of what you request?
They are, Your Honor. Judge Cannoni specifically found a substantial risk existed that any further communications about the evidence or the witnesses would jeopardize a fair trial. And she made that specific finding, and she imposed, I believe it's a 4-part gag order on the Read attorneys. Nonetheless, as shown in my exhibits, Judge, these outside people are receiving information that in no way would the prosecution team ever share outside of anything ethically share anyway, any such information. And there's 3 examples of people who are, out there saying we've gotten this, we've gotten that. And we strongly believe that they are doing so. Just to avoid the slight awkwardness, Judge, of me arguing something that benefits Ms. Read, I would invite, just for the record, the Read counsel to join me in this motion, Judge, because of the leaks that are going on, just as a threshold matter, if I may do so, Your Honor.
Are you merely asking me to add a belt to Judge Cannoni's suspenders?
I think so, Judge, because we need one, and we need one as to the specific information. These 3 people have repeatedly stated that they're privy to inside information, and with respect to Mr. Kearney's information, but although we strongly contend there's nothing in there that is responsive to Your Honor's order, nothing. To the extent that there's anything that's shared between these 2 different prosecutors that are on separate islands due to a stated conflict of interest, we want to specifically ensure that as to the discovery that Your Honor's focused on here, that these orders are in place, that there's a specific order. It's sort of another step from Judge Cannoni. She said that, well, the general rules of ethics aren't working here, so I'm making a specific finding. I'm giving you a gag order. Well, guess what? Judge Cannoni's order didn't work either, based on my exhibits A, B, C. And so we're asking for another step to just really put a fine point on it, that these 3 people must stay away. And a general order as well as part 2 is my part 2. And to the extent that those people have any sort of further expressions of leaks in the media or on the internet, I think that ought to be grounds for a live hearing with sworn testimony about these leaks.
Understood. Okay.
So that's why I'm asking, Judge. Thank you.
Thank you, Attorney Brado. Attorney Yannetti, do you have anything to add on this point?
We don't. I mean, I think that we generally take no position here. It is concerning to me that Special Assistant District Attorney Cosgrove revealed in a publicly filed motion communications with, or I should say between Mr. Kearney and counsel for the Read team when the court's order was specific. My understanding is that he omitted some statements of caution and admonitions that we may have given to Mr. Kearney about the nature of demonstrations, etc. So it seems as though he cherry-picked statements in an effort to make us look bad when it was outside the court's order. It was unnecessary.
Attorney Yannetti, are you speaking to something that Attorney Cosgrove has purportedly done in this proceeding in the 117 matter?
No, I believe it's a motion that he filed in his prosecution. Again, detailed, that material.
Thank you. Okay. Okay, folks, I will take that matter, the motion for protective order, under advisement, and will endeavor to respond to you as soon as practicable on my decision on that. In the interim, ADA Cosgrove, Special ADA Cosgrove, I'd ask you, how soon do you believe the Commonwealth can reproduce the records in question per my order that are called for by the Rule 17 motion?
Well, I would say we can probably extract from the thumb drive the conversations with Mr. Yannetti and Mr. Jackson. I may be able to get it done today. I think Monday would probably be a realistic filing date.
Thank you. We'll expect something by close of business Monday, and if you encounter any difficulty or challenges in doing that, just please let the court know, and we'll make whatever accommodations we need to make. Okay, folks.
Your Honor, is that thumb drive going to get returned to the Commonwealth?
Yes, it will.
All right, thank you.
And it has not been viewed, it has not been released, and it is being held under seal and impounded at the moment, and it will be returned to the Commonwealth promptly.
Thank you very much, Your Honor.
Attorney Brennan.
Your Honor, just for clarity of the record, I'll be brief. There has been no conversations between Special Prosecutor Cosgrove and I about contents of any of these items. In fact, even though I do not think I had to, that's why I filed a Rule 17, so there is a clear public record that we're beyond reproach. Secondly, the pleadings I referred to were pleadings that were filed in Mr. Kearney's case publicly before this issue even came up. So it is not divulging information to disseminate to the public. And finally, just so it's crystal clear, I filed a motion for a gag order in Ms. Read's case because there was significant evidence of distributing protected materials, and that order was allowed at my request. There is no witness or person, as far as I know, in the Read case that has disseminated any information improperly. I would not allow it or tolerate it if it happened. So I want that to be crystal clear based on the representations we just heard.
Understood. Thank you, Attorney Brennan. Thank you, Attorney Cosgrove. Thank you, counsel. No, we are adjourning the hearing now. Thank you, counsel.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
Goodbye.
Court now in recess.
Speak to Mr. Brennan.
You can find me either here or in the criminal clerk's office, probably here.
Okay, check both places.
Thanks.
I will hush.
Thanks,
Okay. I'm going to have a heart attack covering this case. That's all I'm going to say. This is like some of the worst rulings I've ever seen in any case ever. just baffling rulings. So what we're talking about is a pattern here. Oh, never mind. It's just between Miss Read. There's no, why not? It's clearly involved, clearly very, very salient points to the heart of the matter. And what we're seeing is the case being taken apart by judges so that the jury will have no view of the real picture, just sort of like little pieces of the picture. And the poor Commonwealth has to put it together to try to make it make sense for a jury with, you know, I mean, I'll use Dan Rashbaum's analogy, puzzle pieces here. So we have like a tiny little bit of the puzzle, and we're asking a jury to fill in the rest. I mean, it's just absurd, you know, and these judges protecting these lawyers, and Yannetti, you know, I mean, just Yannetti talking about, you know, they didn't see all the times I admonished Turtleboy. Oh, yeah, I'm sure there's tons of them. As you're telling him, like, that's a great idea to get on the courthouse steps with a bullhorn and 100+ people. Seriously. I mean, were we born yesterday? Does he think we're all born yesterday? I can't. I just can't anymore. I mean, literally my head's going to explode. I just feel so terrible for Hank Brennan and the O'Keefe family and at victims of these ridiculous criminal protecting judges in Massachusetts. I can't. I can't. I mean, usually a judge's ruling, at least if I don't like it, it makes sense. To me, this doesn't make sense. The judge doesn't know what he's talking about. He's an absolute moron. Wasn't even like listening. He's like, well, I just said it was between her and Mr. Read. So just that's it. When I know that they spoke on Signal app, it's like the best criminal wins. Tough titties. Commonwealth. I mean, what are we dealing with here? This is, I can't even. All right. That's it. I'll talk about this. This is really supposed to be my day off, but had to stream this one when that finally hit last night. I was like, whoa. At least Yanetti's been exposed. At least for the few people that want the truth, it's out there in these filings. At least it's out there. This is really, this is not just, as I said in a tweet last night, this is not just Karen Read or Aidan Kearney and their, a witness harassment campaign. This is Karen Read and her lawyers as strategy, as part of their innocence fraud, to spearhead a witness harassment campaign. And Yannetti doesn't like being exposed. Well, guess what he did to, I don't think I think it's a little different. His bad behavior has been exposed as they've harassed and made life miserable for people whose crime was being a witness in a case. They're not perfect people. Who is? I mean, just enough of this. Enough of this protecting these criminal lawyers. I'm tired of it. These terrible judges. Awful. This case is going to make me explode. Anyway, have a great day, everybody. I'm going to try to get some rest. I have a lot of work to do today. I will see you all hopefully tomorrow at 6 p.m. Eastern. All right. Have a great rest of the day and night, everybody.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mom. My innocence fraud campaign is my biggest hit yet. I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mark. My innocence fraud campaign is my biggest hit. yeah.